Our next conversation is just getting to understand the law and what the law says about property, and particularly matrimonial property and familial property, and then what happens at the point of division. And this is in succession after death. Our guest is an advocate of the High Court, Eliud Ngugi. He's decided to venture more into real estate and family matters. Eliud, good morning.
Good morning.
Karibu sana to Fixing the Nation. As we begin this conversation, good girl Jano Wama quote is going to give you the day's quote. And let's see whether you make any sense of it.
Okay.
Yes, this quote is by Amanda Gorman, made famous back in January of 2021 during the inauguration at the U.S. presidential inauguration in Washington, D.C. And she said, "There is always light if only we're brave enough to see it, if only we're brave enough to be it." You agree?
I totally agree.
Mm-hmm.
And light in this case, I believe, should be hope. Mm-hmm. And there's always a way out of any dark situation. Mm-hmm. All we need to do is believe. Yeah.
Yeah, that's good. Believe it or be it. Be the one who is that light or that hope. That's good.
There's always hope. There's always a way out.
Yeah.
Always a way out. Now, there are several cases that keep going to court, and we've had conversations around succession here a number of times, and how you plan, how you go to court, where you go to in the event of marital breakup, which court you start in, where you go to in terms of, there's a property case, there's a, children custody case, and then there's the dissolution of the marriage case. And many cases, then we also see cases that go all the way to the Supreme Court, and results that come out of the Supreme Court that have various ramifications, and people just keep wondering, what are we talking about? I mean, what's the case? What's this all about? When one member of this family unit dies, and the other member is left, do they have automatic rights to succession, or must they prove that they were legally married to this other person, and so on and so forth? There are so many other cases. Recently, there's a case that came out of the courts, and particular one, and we ran it on the Daily Nation. Win for Men as court nullifies law requiring widowers to prove dependency. I'm sure you read that story.
Yes, I read that story.
And you followed the story in court.
I followed the
What was the story about?
Well, there was a party that went to court seeking unconstitutionality of Section 29C of the Succession Act of 1981. That provision of the Succession Act provided that for men to be part of the beneficiaries, they needed to prove dependency to the deceased wife. So if your wife passes on and you need to now proceed to court for succession, you first needed to prove that you are dependent to this person. And so that was found to be unconstitutional, because under Article 27 of the Kenyan Constitution, it does provide that that no one should be discriminated on grounds of either gender or marriage. And so that was one. Number two, under Article 45(3), parties in a marriage are equal. They have equal rights. And therefore, you cannot have a higher threshold when it comes to one gender against the other, compared to Section 29(1), which just provides that wives or former wives can easily just prove to be dependents of a deceased person.
Right.
Yeah.
What's a dependent?
What is a dependent? That's a good question.
Let me read from the law. We've called this law the what?
Succession
The Succession
Act.
Yeah. The Law of Succession Act. For the purposes of this part, dependent means the wife or wives or former wife or wives and the children of the deceased, whether or not maintained by the deceased immediately prior to his death, such as the deceased's parents, step-parents, grandparents, grandchildren, stepchildren, children, whom the deceased had taken into his family as his own, brothers and sisters and half-brothers and half-sisters, as were being maintained by the deceased immediately prior to the death, or where the deceased was a woman, her husband, if he was being maintained by her immediately prior to the death, the date of her death. Now, this is the C bit.
This is the C bit.
A says wives, former wives, current wives, whether they were immediately prior to his death, whether they were dependent or not. We talk about parents, co-parents, step-parents, step-children, and all. If the deceased is a woman, the husband can be a dependent if the husband was being maintained by her immediately prior to the date of her death. What is being maintained?
Well, the African setup was that, of course, men would go out and hunt or provide, as women took care of the children, and so
until the land.
Until the land,
yes.
And so the background of coming up with this law was that the men were the ones who were working, and the women would stay at home, and therefore it became the law that women
were
dependent to men. But there was no situation where you'd find that the man is the one staying at home taking care of the children. So that's where that basis came from. Yeah.
So are there any legal loopholes that are being exploited? And if so, by whom? Because maybe I'm referring to this, but I'm also referring generally. There could be, or maybe it's not a loophole, but something in law that you find, particularly when it comes to family law and real estate, is exploited. And if so, who often exploits it?
Real estate, well, death comes to us unplanned. And what happens to us is that we think we have forever to live. We have another 50 years or 60 years, while it comes to us the next second or the next year or the next maybe 5 years. And so you will find that we have polygamous families, we have children sired out of wedlock, and so upon death taking place, these parties appear and show up. The children, by right, under the law, they have a right to inherit their father or their mother. And they will show up and make that claim, come to us as lawyers and seek for our assistance in court, and we shall quote the law, and we are able to exploit their right, or rather go after their rights. So that being said, there are other provisions that maybe, as for example, as Janet, as a lady, you would be able to exploit and choose and say, you know what, before I get into marriage, I shall make sure that I prepare a prenup, a document to make sure that it defines what is mine and what is his, and this shall not be included in the property of a deceased person or in that property. So it alienates that property because it is well-defined agreement that I came in with this property, with this land. Therefore, this belongs to me, and this is how I'm choosing to use it. Other families will choose, or other people will choose to maybe alienate their property and register, let's say, a company, because a company is a separate legal entity, and that company is going to own the property. Or now a recent conversation has been people setting up trust. You create a trust and you transfer all your property in that trust. And so you don't die what we call intestate, where you never wrote a will. You never described or you never planned how you wish your property to be utilized after you pass on. So those are areas that people are able to exploit and take advantage of to make sure that they are safe.
Wow. So that would hold. So I do the prenup. I say this property, I write in the prenup, is mine, property A. It wouldn't belong to me and him. Then I die. That would still hold, or now it would have to be contested.
That will hold.
Yeah.
Because prenups are recognized under matrimonial property. There's a provision for it that you can enter into an agreement before a marriage. And as you get into this marriage, again, I take you to Article 45 of the Constitution, which holds in high regard the marriage union. And then goes ahead to say that that property obtained before in the marriage or after the marriage belongs to the parties or becomes matrimonial property. And so you're able to delineate it because you never got into this marriage, and therefore upon demise or death, no one can come after you. Or rather that property, because they will come in and this document, which is registered, will be produced saying that LRA number this located in this location was already belonging to this party.
But how is that exploitative?
Supposed to be included.
It's just a preference.
It's it's taking advantage of the law. I mean, or
fair enough.
Yeah, it's not a bad thing.
Exploitatively taking advantage of the law.
Is it though?
Is it really?
Is it? Okay, I think exploiting versus being exploitative, I don't know if those are two different things, but I'm trying to see a situation where there's no prenuptial agreements or anything of the sort, and if everything before, during the marriage is considered matrimonial property, but someone else claims that they contributed to that property in one way or the other. So outside of the two parties that are wedded, what happens in such a case?
So matrimonial property can be proved through improvements, which means if you found Latif, let's say Mariam got married to Latif, and Latif had a house which was not roofed. It was still under construction. And as a lady, you came in and you were able to chip in. You took a facility and you put a roof to that house. That will become, you own a share of that property because you improved it. And so you can lay a claim, but now this is separate. This will be matrimonial property, which is upon separation or upon divorce, that conversation will come in where you'll be saying, we own the property together. Or I found him with the property. He has a piece of land, but I'm the one who built the house. And you produce the receipts.
And it's according to your contribution.
It's according to your contribution.
That's okay. That's in the case of separation.
But also in the case of death, you see, the estate of a person is either the property they own or they own jointly with somebody else. So let's say husband and wife own a house, they have gone in together and registered it together. But the wife, before they got into the marriage, had said that when they own this property, that their share will not be included because they owned the land. They owned the land, so the man just only came in and the
contributed for half of the house.
Yes. So there was a document removing this property. Yet, when you go through now the succession process, this house is listed as part of this property or succession case.
How do you balance, okay, this might be an obvious question. The law is very black and white. When it comes to family real estate, there's how emotionally charged it is. Maybe I can ask you as a Wakili, how do you then balance those realities? Yes, the law has said, I'm sorry, so-and-so has passed away, and this is how the real estate is going to be divided or whatever it is. But at the end of the day, there's also that emotional charged moment. And I wonder whether sometimes that also plays a role in the way in which the case could go. Am I making sense?
Yes, you
Would
are.
it ever, though? Law is law, I know, but what you do also has a lot of emotions
The law
and
is very
feelings.
clear.
The law is very clear.
Is it?
Until when it isn't. And you have to go to court to seek interpretation.
Well, it's an emotive journey. It's an emotive journey, and sometimes you're not able to plan for this journey. You may be planning to say, let's revisit this conversation probably after 2 years or 5 years. You don't even You're not even in a place to plan for it. But then situations come. For example, you need to pay school fees. What will happen, yet there was a bank account where the deceased person, for example, was the one paying school fees, and now you need to access this money. You have to go through the court process. And when you go through the court process, because if you don't go through the court process and you start accessing, let's say you even had the ATM, it's a crime. It's called intermeddling, when you access property of someone else who has passed on without getting powers from the court. And you can be imprisoned for 1 year and or a fine of 10,000 shillings. And so
so it's here to, because you know the ATM pin, can just go on.
Nice too.
Yes, but the emotions are there. You are not in a place to decide how to go about it, and that's where the law comes in. And when you look at now Section 28 of the Succession Act, it gives considerations on how to go about the distribution of the property. Either look at the income of a family, look at future income of that family, either look at how the person who is coming to court seeking to inherit was treating the person who passed on. Let's say a parent. If you take care of a parent during their last days, and you're able to come to the High Court during the succession hearing, produce hospital bills, and then it will help you. And you make such a claim, the judge may consider that and say, you should get a bigger share.
So document everything.
Document and everything. So it's important to, even with the emotions, when the law comes, to save you, because you could be in a situation where you want to go for everything. You feel that you're the firstborn of this family, and you go
entitled.
after. You are entitled to everything. But the law will come in and say, no, let's look at the ownership. Let's look at the dependents. Are there children in this family? Let's look at their needs first before we come to you as the adults in this situation. And first of all, cater for their future. Yeah.
We had a conversation with somebody from the family court, and she took us through all this and telling us this is how you begin, this is how long it takes, and the importance of having all this kind of documentation, but still comes to the law and the application. Like now, the way you're quoting Section 28 and saying when considering whether any order should be made, the court shall have regard to the things that you've mentioned, including the situation and circumstances of the deceased other dependents and the beneficiaries under any will. What does that mean? That means that, the court can look here and say, okay, so you have 5 of you, 5 siblings, but so-and-so is not doing so well, so they get more.
Yeah. And that's why I come in here and I tell you, because it sounds very unfair, Mariam.
I'm just like
The situation and circumstances of the deceased other dependents and the beneficiaries under any will. So, I mean, the court has got to look at
All
equity.
factors.
But situations change. You were saying something, but I'm like, yeah, situations change. The sibling that's doing
Well today
very well could be
it.
doing not so well tomorrow, and vice versa. So then I'm like, okay, is it the court's... Anyway, I can't question the law.
Well,
Go on.
you Mariam, I can help you here.
Thank you.
All you need to do is come see me after this. There's a document.
How much is an hour?
The document we need to prepare is a will, because also the court will respect the wishes of the person who has passed on. And the will is a one document that you need to draft and have it well witnessed and have it well drafted for it and executed, for it to help you not to be in a situation where the things you've worked so hard for, end up going to, for example, that sibling who never did much, and now
My
they're coming
argument
to
is
enjoy.
actually the opposite, because I think the siblings should get the same regardless.
Equally.
Because it's not by virtue of you being the good or bad sibling, it's by virtue of you being related to the deceased and being their offspring. Am I mad? Like, are all children not equal before the law?
It's a fair question.
All the children are equal.
And remember, we're talking about dependents.
Yeah.
So it's not necessarily just children here. There could be other dependents, like you said.
True.
We've said parents, we've said in-law, I mean not in-laws, but steps,
Yeah.
stepchildren, and so on and so forth. Now, if you broaden that,
All of which could change the next day. So I think equal is okay. Circumstances could change.
katia kila mtu,
Yeah.
quarter,
I think so.
quarter.
Because even the step, the this, the that, see tomorrow now, maybe something happens. Yeah?
Change.
there could be circumstance.
Circumstantial.
Would circumstance here include, for example, if any of them is with a disability,
Yes.
Okay.
right?
Yes.
And so their ability to is, there's that there, it's a person with disability here, one of the dependents, and so on and so forth, and this is their current situation, and it has been like that for the last 20 years or the last 30 years, and so on and so forth. That could come into play, right?
That will come into play, true. But we are also looking at, have you seen part A of that section 29?
The nature and amount of the deceased property.
No, 29.
Section 29.
Beneficiary.
The dependents, wife or wives, or former wife or wives, former, children of the deceased, whether or not maintained by the deceased immediately prior to his death.
Whether or not maintained or not. So
It doesn't matter if you are doing it in life, you will do it in death.
yes, and so this is where probably for you, you're looking at the siblings, and for maybe Janet or Makot's, for her, it's about the children. Saying, I don't want any other child that I
Creeping out of the woodworks.
Yeah, coming from nowhere, being able to get what I've worked so hard for. And so in this regard, and it's a very painful situation, especially if you are in it, where if a deceased person had a proper will, and that will decided that Mariam was not my favorite child, and therefore Mariam only gets, let's say, a movable asset, like just a car, and the rest of the children are getting acres and acres of land. It's very uncomfortable, but the court will respect those wishes on that will. And we have seen people rush to court to try and say that that document is not properly executed.
We are going to a break. But 28G says that the court shall have regard to the general circumstances of the case, including so far as can be ascertained the testator's reasons for not making provision for this dependent.
Okay.
For not making provision.
Yeah, for what reason? Ati damu yangu na yake. Huyo alinitukana akiwa teenager.
Eric, though, for not making provisions, not for making smaller provisions.
Provisions. Let's come back and unpack it. Let's come back and unpack it after the break. I also want to know what are the common legal mistakes Kenyans make. And I think we've asked this before, but just hearing from Wakili, what are the most common legal mistakes people make, especially when it comes to real estate? You can call us. The number, Mariam ameshika number ata 0719 038
There we go.
0719 038 you can call us, send us feedback on social media as well. We're back in a bit. It's coming up to 8:30.
Questions ka huyo ametuambia tu oya anawatambua sana nikiwa CBD Mfangano.
Oya.
Siku
Zombo tote.
Basi.
Obed anauliza, Wakili, I'm asking a question. Is testamentary trust similar to a will? You'll answer that in a bit.
Okay.
The other one from Peter Njoroge. I beg to differ with Wakili. A beneficiary who is not adequately provided for under a will has the right to challenge a will for inadequate provision, and our courts have challenged such wills. React to those two statements.
Well, testamentary?
He said, is a testamentary trust similar to a will?
No, it is not. A will is a document that is used to show your intention upon death. Testamentary trust, maybe they mean a trust. It's an entity that you register to handle part of your assets. Yeah.
Okay. The other one was talking about such have been challenged before in the courts, that a beneficiary who isn't adequately provided under a will has a right to challenge the will for inadequate provision.
Yes, we have seen quite a number of cases in court, because like I've said, it's very uncomfortable upon demise, let's say, of a parent, and when you sit down to read the will, or to read the will of a parent, and you find that you have not been provided for. What do? You will proceed to court, and the courts have given that chance to people to come to court and challenge a will, but there are provisions under the law how you can go about challenging a will. So either you could look at the execution or the witnesses present at the same time during the drafting of that will. Was a person who wrote the will, now the deceased person, of the right mindset. You could raise issues saying that they were very unwell, they were coerced. For example, there was a child who was standing there with, let's say, the capacity to take care of a hospital bill, and that influenced how that will was written. And so if you have the evidence, and we have seen it happen, our courts will welcome you to come and file and challenge a will. If you feel so, and you have evidence to prove so, that you are not adequately provided for, then you can challenge.
Yeah.
Let me ask. Oh, we have a caller, but just before we get to Caxton, after we talk to Caxton, outside of those challenges, Judge Sema tu woye ake ni unfair alafu akupe. But let's listen into Caxton from Butere. Good morning, Caxton.
Morning to you again.
Good to hear from you. What's your question?
Nina swali langu la kuuliza huyu ajaribu kufafanua habari ya ile public trustee. What happens when it is taken to public trustee? How long should the public trustee actually look for people who they go to their addresses with their contacts?
This is okay. So I think we've understood the question. Yeah. So thank you, Caxton.
Yeah. On public trustee, when everything goes to public trustee, please.
Yeah. Okay. I'm assuming this is what happens when there are no dependents to be found and things like that, and then is that
no,
different
this
thing?
is when you pass on, and some of your assets are found. For example, your M-Pesa, money in your M-Pesa, or a bank account that had money that the family never knew about, or a property also that was not included. It is taken back by the government, and there's a notice sent out to the public in the papers inviting you to make a claim, and this is what we call unclaimed assets.
Right.
And so the notice is given out by the unclaimed assets for parties to go out and make their claims for what is owing to them.
There's also the other bit. If I remember what the magistrate from the family court told us, that in this process, when you file, there's a period that's given for the person now who's appointed as the immediate trustee to go and find out all the information on all the assets that belong to the deceased, so they can all be consolidated for purposes of now subdivision for inheritance. And at this particular case, the family can decide out to skizani, so the court appoints a trustee, or you all appoint a third-party trustee. So I think that's what Caxton is asking. In such a case, when this person is out there, antafuta pesa, ama they're the ones now who are like sort of quasi-managing the property.
How long should they stay in that role?
Now they're given timelines by the court to go out and come back and have a collection. In my understanding, it should be around 6 months, where they go and just collect that information on all the assets owned by the person and come back and report.
Our alternative, follow up.
No, I just wanted to do the question from before the break, because I genuinely do wonder, Yes, outside of contesting this will and saying this person was not of sound mind, this, can a judge just say this was unfair distribution? Oh yeah, here you go. in legalese.
Legalese, that it was just
like this was unfair.
The law is
when the court is considering these things,
yes,
because the court is supposed to consider Section 28. Can the court come with hapa ukweli huyo alionewa?
You see, you're not the only party in this case. When a succession case is filed, one of the things that happens is there's a gazette notice that is whatever by the government printers. So there's a notice issued out by the government printers inviting any party who is unhappy, who may need to be aware that so-and-so's assets are being now taken to court for succession, to come and either protest or seek to be involved in the process. And so that notice goes out and the public is given 6 months to come to court. So once there's a government printer issues that gazette notice, then you're invited to come in and come to court. So you may be the voyeur. You may be the person who is unhappy with how the will excluded you, and you come to court. You're going to meet the other part of the family. And so the judge, and that's why you see that the equality signs of any court is that the judge should, the weigh skills. The judge is supposed to issue a determination that is equal or makes everyone feel that they have been
addressed. I got a couple of,
in this regard, the person, the family, will make a very strong case why you should not be included. And so in making that determination, even if the judge was to feel then there are other courts. You can move from the High Court and go to the Court of Appeal, even try and get into the Supreme Court if you feel that the judge did not make the right decision.
Okay.
Or maybe did
they
not feel way for you.
Okay.
0112500 our WhatsApp number. People are asking questions here, Wakili. So first we start with Wakili Njenga, who says it's not all beneficiaries who can challenge a will for want of adequate provision, but only those beneficiaries who are dependents, for example, widow or kids who are still in school or colleges. Correct?
Yeah.
Higher. There's a question. And this is Wakono from Bungoma. What about the people the deceased stayed with for over 5 years and they were not included in the will? Okay? Then there's another one here. Ask Wakili, if I'm staying with a relative's child because it's probably convenient for the subject child to attend college from my home, I maintain this child while she's living here, maybe contributing to their education. Does that constitute maintenance? Will they be entitled to inheritance if I pass away intestate?
Interesting.
That's
probably very common.
It's very common in our...
You're a guardian for this particular child. You're contributing to their well-being. You're paying their school fees and all, so you're maintaining. Okay? So can they come and say, she was maintaining me?
And this is someone over the age of 18, I'm assuming, because they're in university or college. Yes.
Well,
there's another one. Let me just ask another one, and you can answer the three. Hello, how about when a dependent is not provided for? And when I went to court and the ruling said I had benefited from it via my education. Yet my mother has not been given anything, yet she's a dependent and I am the beneficiary. Do you understand the question? How about when a dependent is not provided for? And I went to court and the ruling said I have benefited from it via my education. I've already benefited from this estate via education. But my mother has not been given anything, yet she's a dependent. So this sort of sounds like this is from another family, right? So here I am. This person was paying for my school fees, okay? And now I'm going to court and saying I'm a dependent of this, but I'm an adult. My mother is not getting anything out of this. the court says you already wewe ulilipwa shule. Sasa malizana na marehemu.
You say, let me start with that last question. The provision under Section 29 on who is a dependent is very clear. Wives, children, stepchildren, uncles, and then goes to husband. Kuna former wives. And so when you read this provision and maybe you had come into their family and a deceased person was the one taking care of you, if you do not fall under this category, it becomes very difficult for you to now qualify yourself as a beneficiary because the law is clear. You're either a child or a relative in this family. In that regard, then, you, what the court did was in accordance with the law. But how to bypass it, then, is to say that, for example, for Eric having so much love for let's say, a certain organization, you can give a provision for that organization, and nobody is going to come and challenge it. And that's why wills are better documents, because they allow you to provide or to give provision that are not under the Succession Act. So I could be having a child, my domestic workers, or my driver's child, somebody in that family, I could decide to educate them and even have a provision in a will saying, you know, because this driver was very good, then I'm going to educate this child and I'm even going to give them 2 acres of land.
Okay.
And that one will not be challenged because you have
Put it down.
Put it down in a will.
Let's pause you there. Peterson from Nairobi wants to ask a question or maybe share a comment. Peterson, good morning. Please go ahead.
Yes, good morning, Bugwa and Eric and the rest. Yes, please. I think the discussion is really touching, and if we really want to talk about, I think we should reflect the community right now, because I will give an example. I had a friend of mine when still in university. He got a girl pregnant and he had a baby boy. So when he got they separated when the university, but still remains this child was for the guy. So when he got married, they got kids. He came to know that in this marriage, the other child was out of the wedlock. But it was his responsibility to bring that child to the family and introduce the child to the family. So let men not shout. They should have time. Although you have 3 or 4 children outside there, be bold to tell your wife or your family that you have kids. Bring them to the family so that the family members know them. And also it's your responsibility, if you know that you have 10 acres, have extra 10 acres for the children who are also outside of the deadlock. This will be really better to handle the cases, such cases. Okay. Thank you.
Thank you.
Thank you, Peterson. There was also the question on the college. For example, someone is staying with you. I'm not sure if they're a minor or not in this case. I don't know if that changes anything. But yes, a relative is staying with you. They're attending college. Perhaps you're paying a little bit of the school fees or maybe the whole of it. Would the law potentially see them as your dependent should you pass away interstate?
So Section 29B does have that provision as were being maintained by the deceased. It says children whom the deceased had taken into his family as his own, brothers and sisters and half brothers, as were being maintained by the deceased immediately prior to his death. So if there are children whom the deceased had taken into his family as his own, then there will be a provision.
Now this is where things get tricky, Wakili, because define, this is, they have their parents, I'm assuming. It's just university college is closer to me. So they live with me, and I am a good aunt, a good, sibling, a good anything, and I help pay part of the school fees. Is that taking them as my own legally? That's a very vague.
The law is saying that you were showing that you are maintaining
you are being
them.
maintained by the deceased.
Yeah, prior to their death. So as long as you're able to prove that, and I think the drafters may have been trying to not destabilize, for example, a child's right to education, because under the Children's Act, every child has a right to education, and there's no proper order that this right to education is in a family unit or not in a family unit.
Right.
As long as you're a child, you have a right to this education, and if you're being provided for by even someone else in a certain family, we don't want to destabilize you. We want you to continue having that access. Yeah,
I can see the case here, especially now that you're bringing that angle for the child, because a child's benefactor has died, right? So what happens to this child when the benefactor has died? Even if this child is not necessarily from the immediate family, this child is not your nephew or niece, that you're helping your close relative to support this child. It's a child that you basically just decided, you know what, I like this child, wherever they are, wherever they come from, I've been supporting them. So does that mean that because you've been maintaining, you've been supporting them, you've been paying their school fees and even sending for their upkeep and saying, here, even when you go home during holidays, for you and the family, you're actually showing that you are benefiting from this person. After the death, they're entitled.
Yeah.
Right? I was going to ask a common legal mistake that people make. I would want to say one of them is just not putting it pen to paper, right? Just leaving things vague and open. Would you say that, or is there another common legal mistake people make when they're acquiring land? Yeah.
Not using professionals. So you choose to go to even the chief, and the chief is the one now handling your transaction. And because you want to save the money, the economy is tough, you choose to go through that process because you want to save that money. You decide to even do it yourself, only to get stuck, where in a transaction, you have gone for that. Another mistake you might make is not having your own legal advisor, for example, in purchasing that property. So you're using a common lawyer of a seller and you're the buyer. And so you, without understanding, is that, you see, the seller is the one who have a kick. And this lawyer will be acting in their interest. And therefore, once the documents have been handed over, or once you've made for example, your deposit, there's no one there to follow up on this balance or in this registration to be finalized. So you are caught in between some situation because you chose to use a common lawyer rather than have your own
helpful,
to fight for you.
I think a lot of people, they're just like, see tumelewana. See, you've given me. I think people undermine.
Yeah.
It may sound obvious, but a lot of people bypass these things, right? Which is why I think it's important to ask. Do people also not take advantage of alternative dispute resolution courts? And if so, why? Or is it like, no, people are taking advantage of ADR as opposed to immediately escalating it to court? What have you observed?
People have no information. The information is not out here that apart from going to court, you can have a mediator. You can have an arbitrator to resolve the dispute between you before rushing to court. And so, or also, when you're getting in your contracts, signing a contract, you just go on the website and just download a document that says that you shall resolve the dispute through arbitration. And arbitration, yet it is fast, that's the advantage of it, but arbitration is costly. So you just go for that option before going for this easier option of, first of all, mediation, that you can go and have a conversation between the two of you.
And arbitration is legally binding.
It is legally binding. You get an arbitral award, and once a judge sees that there is an arbitration clause, they will not entertain that contract. They will send you back to go and resolve that issue. So people are not taking advantage of this alternative dispute resolution. A fun fact, one of the alternative dispute resolution involves going to the elders as per our constitution, and people don't do that.
No.
Yeah.
Ongelesha was there.
Yeah.
Hey, I that one I struggle with, and I get where it's coming from. It's one of our dispute resolution mechanisms from time immemorial. But then I think of how the system is set up, especially for women, and I'm just like, do you want the Council of Elders to be the one to
sort this
out? But that's a story for another day.
Communities have moved and have really transformed themselves. Just looking at the local community and all, and that's why the alternative justice system and those courts as well, they're also cognizant of very many things that are going on. And I think many of them also have now representation of women sitting in them, especially those that have been formally set up.
Using women.
Using the
I don't think so. You should get a case study. You should get a case study of somebody who has managed to resolve. I think that would be important. It's a story that's not told well enough. Eliud Ngugi, real estate and family lawyer, thank you so much for coming and shedding light. When death does you part, who owns what? And then you could document everything, pen to paper. I think Wakili has said his bit, though. Next, we have a heavy conversation, but a very important one. We'll be speaking to Deline Adhiambo, who is a clinical psychologist. We'll be tackling sexual abuse against children. We'll have that conversation in just a moment, coming up to 9 a.m. on Fixing the Nation, one conversation at a time.